starting with the State of Ohio versus Brandon Franklin. That's case number 29071. The State of Ohio has waived their argument, so we'll be hearing just from Attorney Ludwig on behalf of Mr. Franklin. We've read the briefs, of course, and are ready to proceed. If you are, Attorney Ludwig.
Thank you, Your Honors. If it please the court, my name is Mark Ludwig. I have the privilege of representing Mr. Franklin by appointment of the trial court. I apologize in advance for any dinosaur politically incorrect sexist views I may evidence. I think that both the trial court and the good Lord are behind having an older attorney argue this case, but that remains to be seen. When I first looked at this case, I saw here's a sex offense case where the rape shield law does not apply, and it's a one-on-one fact pattern, and we're rather soft in dealing with the victim. That may be the politically correct thing to do these days, but one of the reasons we have a rape shield law is many defense lawyers abused that attack on a victim. This case could be nicely described as, does substantial impairment mean one cannot consent as a matter of law? In other words, does a voluntary substantial impairment by alcohol or drugs prevent consent? Does sexual battery under 290703A2 criminalize any sex with a drunk? That's the harsher way to say it, and that is the view that the state has argued in opposition. There is no such thing as consent versus a 290703A2 offense.
Well, isn't that the purpose of the statute? Because the whole point is this is substantial impairment means that you are not capable of consenting.
No.
And a reasonable person would
No.
understand that.
No, that's not what the statute means. In fact, of the 12 provisions of 0702 that are yet not been ruled unconstitutional, if you're a police officer, it's unconstitutional under Section 13. But of those 12, 11 of them are all designed to protect the status of the victim. Either it's a young victim, it's an older victim, it's a person in guardianship, it's a person, a stepdaughter, a stepson. There's some relationship being protected. This is a pure 290703A2 case, and by that I mean this is impairment. The only reason we have a sexual conduct charge brought is the victim claims to have been substantially impaired. And which comes first? The substantial impairment or the consent? Which subsumes the other? And what I submit is that for substantial impairment, the issue of consent can still be open. Now, the state takes both approaches. The state's brief at page 30 says, this case is the quintessential example of a vulnerable person who could not control her actions or provide legal consent to sexual conduct. Well, now, which is it, state? Is it consent has nothing to do with this case, and the word should have never been mentioned at trial, and it rarely was? Is that what this case is about?
I'm not sure I'm understanding why those are inconsistent.
Pardon me?
I'm not sure I understand why those concepts are inconsistent. If you're substantially impaired,
You can consent. If I'm substantially impaired, I can drive a motor vehicle. If I'm substantially impaired this minute, okay, I can stumble and I can slur my words, but I can still say, yeah, I want something. Now, how wise is that decision? Whether a jury agrees that I was really consenting or I was really understanding Well, to make that decision, they have to hear about consent. When you read this transcript, as you read this transcript, you know, during voir dire, that was one of the first questions the juror asked. Potential juror who became a juror, number 13, asked, wait a minute, I understand you're talking about she was impaired, but can't she consent? And when you read that exchange on 169 of the transcript, you'll see that the state dodges around this in trying to answer the juror's question, and ultimately the trial judge said, stop. We'll get to that later, and they never did.
Well, does it really matter though in this situation where she says she was completely passed out and somebody?
She wasn't charged. She wasn't charged. This was not an A3 charge.
I understand, but still, you have so much evidence of substantial impairment here, right?
You have so much evidence of drunk,
Her being
voluntarily intoxicated. Let's not color it softly with the words substantial impairment like the statute does. Those are the words the jury's going to have to hear. But let's keep in mind that she was drunk, and she said, and the grand jury did not charge that she was a passed out victim. They didn't charge her. This isn't a case where the prosecution chose to charge an 03A2 and an 03A3. And then we just kind of throw it all at the jury under charging both counts, and they come back finding one, both, or neither. This record isn't presented to you that way. For you to turn and say, well, because she testified she was passed out, that proves she could not give consent. That jump doesn't follow under the charges brought, Your Honor. And you have to deal with what we give you in that box to deal with. And they didn't give you the box of she was passed out, therefore she could not have consented. They didn't even ask her if she consented or not. They never asked. This record is devoid of that question to the victim.
Well, I would presume one of the reasons why nobody asked is because she'd say, I was so drunk, I have no idea.
You presume that's what she would have said. Well, we'll have a different record if we're allowed to retry that case and somebody asks, Your Honor. But presuming that's what she would say is not what this record said she said.
I understand, but the point is, when she's saying she can't even remember anything, I think the jury could look at it and say, well, you know, whether she was charged on consent or not, whether they're charging on consent or not, the jury could look at it and say, how in the world could she even consent whenever.
Your Honor, you're jumping there. You see the jump you're making.
I know exactly what I'm doing, and I understand. I'm trying to get you to
That's
talk to
the
me about
jump. That's the jump that's wrong
Do you
here.
have
The jury needs to hear, as that first juror was asking during voir dire, can't you consent even when you're substantially impaired?
Do you have any case law that says that?
No, and neither does the state. And one of the problems that's dumped on you in this case is that there are very few what I call pure 03A2 cases. This is a one-count 03A2 case. Now you get all kinds of other fact patterns and all kinds of other problems when you add the gross sexual imposition, where it's particularly charged as an element that they had to prove there was no consent or ability to resist. As soon as you start adding other charges or even other 290703 cases, multiple counts of battery, it loses its purity as to this question. The 8th District, I have struggled, and I wish I had the brains to explain this to you. Felton in the 8th District says, if the offender knew the victim had no ability to appraise or control their own acts, the offender would certainly know the victim couldn't consent. Well, that sounds like a nice, hard and fast rule that we can follow. Ebreth in the 7th District says, proof of substantial impairment of the ability to resist or consent would necessarily prove the inability to appraise the nature or control. Again, we've got resist or consent, appraise or control. But then Ebreth added this, which I think is very wise. But the converse is not necessarily true. Felton's paragraph 35, Ebreth's paragraph 33. And Ebreth says, look, if we prove that they couldn't resist or consent, you've necessarily proved that they're not in substantial control of themselves. But then it says the converse isn't true. And what's the converse? Proof of ability to appraise the nature of or control conduct is not necessarily proof of ability to resist or consent. Oh, and by the way, for what it's worth, and I'm sure it will be found just to be a factor, but, Your Honor, this victim never identified the defendant as the guy that was there. Now, on a Rule 29, when the victim hasn't identified the defendant, I have some difficulty with why that Rule 29 was walked by. But again, we're talking...
Did you raise that as an error?
No, but I did rate the insufficient evidence and the denial of the Rule 29s.
Of course, there's no issue really that they had sex. The whole issue, like you said, was consensual.
But when does that become a non-issue? Who makes that a non-issue? At what point in the case? Might want to look back on that thought as to the initial Rule 29. Did anybody argue a Rule 29? No. It was, we've all been there. It was Rule 29 denied, Rule 29 denied. That's what we become lax in.
Did the defendant's counsel attempt to raise consent as a defense and
No.
not permitted by the
No,
court? That's part of your ineffective claim.
Yeah, that's part of the ineffective claim. I don't want to try the victim, right? Unless it's a permissible tactic that could prove that my client was aggravated stupid and in retrospect should have never had sex with this lady. But what the premise the state has left us with is when a drunk says yes, it must mean no. And Brandon is the only one who testified about what the drunk said. And
Well, he's actually the only one who knows, because she testified that she remembers nothing about leaving the bar on the ride home, but woke up at home in her bed having butt sex. That's all she remembers.
that's all she
So
wrote,
That's
Your
all she
Honor.
testified to. I don't remember anything,
Yeah,
nothing.
no, she remembers waking up and having anal sex.
Or doesn't remember leaving the bar, doesn't remember the ride home, doesn't remember
That's
going
what
to
she
the
said.
house, doesn't remember any of that stuff.
That's what she said. Her sister also said, transcript 330 through 336, her sister also said that my sister is an adult, she's able to make her own decisions, and she was able to comprehend and understand what was said to her at that drinking. Now,
That was during the time that she was in the bars and the restaurants prior to leaving the last bar, right?
yeah, that's the last time the sister saw her. And it's also the state's position at page 12 of their brief that evidence of substantially impaired must exist, and this is page 12, during the sexual conduct.
You got 1 minute. 1 minute left.
Your Honors, I don't understand how they can say we must have evidence during the sexual conduct, and there isn't. Well, they're wrong. They don't really mean that when they said that in their brief. How they can say that this is a quintessential example of a case where the victim couldn't provide legal consent, and yet consent is not an issue. Consent is an issue. That's what this case swings on. This is us old-fashioned ones. This is the classic one-on-one.
Except that somebody was so drunk, according to the record, that they couldn't even testify as to what happened.
So really,
Yes,
he
but
said-
someone who wasn't so drunk, Your Honor, could testify as to what happened.
But that's the whole point, isn't it?
But the jury didn't know that that was important. The jury didn't know that the issue of consent was important. And in this record, during void, they didn't. They weren't asked about consent. No witness was
Well,
asked.
once
They
she
weren't
testified that
charged.
she doesn't remember anything that happened, what are you even gonna ask her? If she doesn't remember, is she gonna say?
Yeah, but wait,
"Might have
you're
been
focusing
consent
on the wrong person, Your Honor. The person is this defendant who said, I did ask her, who said she was signaling to me. That evidence supports a charge of, you may find she consented. Now, if we genuflect at the point of, she said this, therefore,
We only know what he says she said. We
Short
don't know
answer,
anything
because you're out
else.
of time.
thank you, Your Honor.
All right, thank you, Attorney Love. Court will take the matter under advisement and issue a decision in due course. Of course, the courts will mail you a copy of the decision on the day it's released, and the opinions are also posted on the Supreme Court's website, as I'm sure you know. Thank you very much for your
Thank
time.
you, Your Honor.